Good afternoon, my lord. Miss Hughes for pursuer, my lord. This case is calling for debate today. I rest assured my lordship has all of the relevant documents at his disposal, namely the record, the productions, and the authorities, my lord. I wish for the court to grant decree de plano as craved. I wish to repel all of the defenders' pleas in law as denoted as numbers 1, 2, 3, and 4, my lord. My lord, this case involves the simple matter of liquid and illiquid debt. It is admitted by the defenders that they are owed liquid sums by the pursuer in respect of their first plea in law. In relation to the parties' contracts for the supply of asphalt to various locations on various dates. There are no averments, my lord, that the pursuers were in material breach of those contracts. However, the defenders in this present case seek to retain payment of those amounts pending determination of the counterclaim. They cannot relevantly do so, my lord, as those supplies relate to separate contracts entirely. Thus, my lord, decree should be pronounced for the admitted balance due. The pursuers in the present action seek payment of sums due under and in terms of the contract. The defenders have made a counterclaim for damages arising out of the allegedly defective performance of the contract. However, there were numerous individual contracts between the parties in this action, my lord. Therefore, there has only been one instance of material breach which has taken place in one specific contract between the parties, my lord. Thus, the right to retention of all sums of payment will only apply in that specific contract and not in all other contracts between the parties, which were in fact duly performed by the pursuers. The pursuers in this present action supply the defenders with various supplies of asphaltic road surfacing material. The nature and extent of the goods supplied are set out in the pursuer's invoices to the defenders, my lord. It is the position of the defence that the defenders are entitled to retain any and all sums which are due to the pursuers, my lord. However, this defence in law is wholly incorrect and thus proven through certain case law, which I will examine today. The right to retention, my lord, was explored in the leading case of the Bank of East Asia Limited against Scottish Enterprise, House of Lords, 1997, Scottish Legal Times 1213. I refer to the case of Bank of East Asia Limited against Scottish Enterprise, which was an English case, however, which relied entirely on Scottish law as it dealt with the law of retention. This case concerned a contract between the Bank of East Asia Limited and Scottish Enterprise. Scottish Enterprise asserted that they were authorised to withhold payment of sums which were owed to the Bank of East Asia Limited under the contract between the two parties in relation to past performance of an earlier stage of the contract, my lord, which had already been performed properly. I quote from the ruling from Lord Johnsey in this case, who stated that retention may be operated against corresponding obligations prestable but unfulfilled, but has no relevance to obligations duly performed. Thus, my lord, Lord Johnsey's ruling is irrelevant in this present case, as it demonstrates that payment for services already performed accordingly cannot be retained. Therefore, the defenders in this present case are not entitled to withhold payment for individual contracts with the pursuers which have been duly performed and upheld by the pursuers, my lord, and their position is not a defence in law and is in fact wholly incorrect and unreasonable, my lord. The right to retention was also further explored in Purac Limited against Bizac Limited 2005 Scottish Legal Review. This case involved the entering into of a consortium agreement by the parties in which the court considered an application of section 42 paragraph 2. Most importantly, in relation to this present case, the court contemplated the need to preserve the integrity of the parties' contractual agreements. When considering this point, the application did not in fact succeed. In the ruling by Lord Drummond-Young, it was held by Lord Drummond-Young that the right of retention will in fact only arise in the instance that one party is in material breach of their contractual obligations. Therefore, I refer to Purac Limited against Bizac Limited, my lord, as its ruling demonstrates that in this present case, the right of retention in fact cannot arise for these completed contracts, as the pursuers cannot be in material breach of contracts which have been already completed. Thus, the defenders cannot withhold payment for the numerous contracts completed with the pursuers. This ruling by Lord Drummond-Young in Purac Limited against Bizac Limited demonstrates the lack of defence in this present case indeed. Most recently, my lord, the right to retention was further examined and explored in the case of Inveresk Public Limited Company against Tullis Russell Papermakers Limited, 2010, United Supreme Court 19. This case, my lord, involved the asset purchase agreement which Tullis Russell entered into with Inveresk Public Limited Company on the 9th of June 2005 to acquire the property rights to the Gemini brand of paper. Two issues arose in this appeal, my lord. Firstly, it had to be determined whether Inveresk's alleged additional consideration had become due and payable under the asset purchase agreement. Secondly, it was to be considered whether Tullis Russell was allowed to deduct the amount it claims in damages from any payment it is obliged to make to Inveresk whilst the claim was being resolved. The appeal was unanimously allowed by the Supreme Court, as it was found that a right of retention may in principle apply. Thus, this case again involved a similar situation to the present action, my lord, as Lord Hope, in his ruling, declared certain exceptions in which a right to retention will be upheld. However, when these exceptions are then examined, they demonstrate their lack of suitability in this present case, my lord. Lord Hope ruled that the most important question in determining whether a right of retention may apply is to consider whether the relevant obligations can truly be said to be counterparts of one another. In the case of Inveresk Public Limited Company against Tullis Russell Papermakers Limited, it was found that both the asset purchase agreement and the service agreement between the parties were expressly linked with one another and therefore formed one individual transaction. Thus, it was found by Lord Hope that a right of retention did in that case apply. This ruling from Lord Hope demonstrates a certain exception where a right of retention for the payment of sums will be upheld. However, when applied to this case, it clearly demonstrates the lack of defence in this present action. This exception, of course, does not apply in this present action, my lord, as each contract between the parties was separate and individual in their very nature. This therefore demonstrates that the defence is wholly incorrect in law and a right of retention cannot be upheld. In terms of the first crave of the writ, my lord, the pursuers crave the court to grant decree for payment by the defenders to the pursuers of the sum of £43,200 sterling, my lord. Of course, together with interest thereon at the rate of 8% per centum per annum from the date of citation to follow hereon until payment. Payment of these sums is sought in this present action by the pursuers as payments of sums is due to them under and in terms of the individual fulfilled contracts between the parties, my lord. This payment is not entitled to be withheld, and the position of defence is clearly wholly incorrect in terms of the law, my lord. In terms of the counterclaim, my lord, I ask you to fix a proof in order for that matter to be dealt with. If successful, my lord, I also ask you to find the defenders liable in expenses for this action. Thank you, my lord.